The International Criminal Tribunal for the former Yugoslavia is now in session. L'Audience Tribunal Penal International pour l'ex-Yougoslavie est ouverte. Please be seated.
Good morning. Mr. Registrar, could you call the case, please?
Good morning, Your Honors. Good morning to everyone in and around the courtroom. This is case number IT 0588T, the prosecutor versus Popović et al. Thank you.
Okay, thank you. All the accused are present. Representation, the only change I can notice today is the presence of Mr. Mitchell. And it's Mr. Van der Puy and Mr. McCloskey. Mr. Tyre is not present today. Incidentally, Mr. McCloskey, when you've come, the prosecution has come to the end of its oral, of its closing arguments, we may have some questions. And for that purpose, I think the presence of the entire composition might be required, because there may be questions which Mr. Van der Puy will probably need to answer, questions which Mr. Tyre, and so on and so forth. So please keep that in mind and make the necessary arrangements. The other thing I wanted to say before we give you the floor, Mr. Van der Puy, is that and from this part onwards, Mr. Registrar, it will need to be copied and incorporated in a letter which goes to the President and to the Registrar. One of the problems we had relating to the final briefs and reading them and be prepared for this now final stage of closing arguments was the fact that one of the final briefs, and a very detailed one for that matter, was in French and needed to be translated into English for most of us to understand. Now, some time back I had, together with my colleagues, met with our senior legal officer and also the senior member of the CLSS, and we had organized the translation to be possibly finished in time to make it possible for the schedule to be kept. There were difficulties, of course, because it's a department which sometimes we are ungrateful to, sometimes it's harshly criticized, but which in my experience has also always done the level best to meet our requirements. They did the same thing this time, and I think I need to acknowledge it publicly in the courtroom. They kept the target date, and they came with the translation when expected, on the 24th of August, which made it possible for us, and I assume for you, to read it thoroughly. Also, I must say the translation was of a very high standard, barring some very minor mistakes. The rest is perfect, and I think I owe you, I owe CLSS big thanks on behalf of the trial chamber, and would like you, Mr. Registrar, to communicate this part of the proceedings to, as I said, to the President and to the Registrar for their information. Yes, Mr. Van der Puy.
Thank you, Mr. President. Good morning to you and your honors. Good morning to counsel. Good morning to everybody. Yesterday, when I left off, I was talking about evidence. I'm sorry, Mr. President.
Go ahead.
I was talking about evidence as concerns Mr. Bayar's presence in JEPA. I won't repeat that, but I will put on the record, for the benefit of my colleagues and for the trial chamber, the transcript reference, which is at transcript page 14603, 22 through 14604, line 7. With respect to the defense assertion concerning forcible transfer and Mr. Bayar's participation in that joint criminal enterprise, they assert that there is no proof of contemporaneous or even subsequent knowledge of the civilians, and that's at paragraphs 376 through 379 of the brief. The claim is that, quote, Mr. Bayar was not in Popović and not aware of the crimes committed in Popović, including the transfer of the civilian population. That's at paragraph 401. First, it is clear in the evidence of this case that his subordinates were on the ground in Popović. Mr. Popović concedes that he was present there. He doesn't contest it. Momir Nikolic was also there, and they were in the thick of things. The main staff and Drina Corps command structures were also clearly involved. Now, to suggest that Bayar had no awareness of the predicament of the population is, to say the least, untenable. To the contrary, the knowledge and awareness of events, including the crimes perpetrated there, can be reasonably inferred from the conduct of his professional subordinates. His knowledge of those events is also implicitly shown in his interactions with Mr. Chalanovich, PW 161, Miroslav Derenich, as well as Momir Nikolic. He knows about prisoners. He's got to know how they came to be in Bratunac. He's got to know that many of them were separated and the circumstances under which they were separated. And it's abundantly clear that he knows what will happen to them. He exercises specialist control over the security organs in subordinate commands, and he has to know what they're doing and why. The rules of service indicate, and this is at, the exhibit number is P00407, it's paragraph 12, that security organs report on their work to their immediate superior and the security organs of superior commands, units, institutions, or staffs in accordance with the provisions of these rules. There's no question that Mr. Bayar knows about the predicament of the civilian population in respect of their transfer. I want to also refer the trial chamber to P00480, and this is an interview that he gave on 29 October 2002. And in that interview, it's on page 7, he was asked whether or not he participated in the operation of the Serbian forces entering Srebrenica. And he responds that he was away, he was on the Bihać front, but he returned when it was over. And he says, one day when I was taking mail to General Mladic, I saw a large number of buses on the road leading from Bratunac to Žepa and Srebrenica. The vehicles were sent from all over Bosnia to transfer the Muslims to Tuzla via Kalesija. An UNPROFOR convoy was providing security. To suggest that Mr. Bayar doesn't have any information, contemporaneous or subsequent, with respect to the civilian population and their forcible removal is, as I say, untenable. The defense brief also asserts that there was no ethnic animus that was part of the character of Mr. Bayar, and that if he committed any of these crimes, it wasn't motivated, essentially, by that animus. I think you've seen the evidence of that animus at this trial. You've seen it evidenced in the intercepts by his persistent and continuous use of pejorative and derogatory remarks to describe the Muslims. You've seen it used in official documents that he's distributed to his subordinates and to his contemporaries. I won't go into all of those because I think the record is replete with the evidence of that animus. And I would submit that it infected Mr. Bayara's behavior, and it infected the motives with which he participated in the commission of the offenses that are charged under the indictment. In the prosecution's opening address, Mr. McCloskey referred to Mr. Bayara as an empty vessel. At paragraph 493 of the Bayara brief, the Bayara defense suggests that this means that he had no power or authority to influence the course of events. Even though Mr. Bayara was not a commander, of course he had the power to influence the course of events. Of course he did. And vested with the powers, the authority, and under the orders of his commander, he clearly did. He influenced the course of events, and he significantly contributed to the JCEs that are charged in the indictment. Those events, as you know, and as is proved in this case, culminated in the murders of thousands of people and the genocide. There's been no evidence of remorse in this case for Mr. Bayara. I think the evidence actually points to the contrary, and it's something that we would ask that you consider in determining the appropriate sentence should you find him guilty of the charges that are contained in the indictment. Again, I will refer you to the interview that he gave on 29 October 2002. At page 7 of that interview, despite Mr. Bayara's clear involvement in the crimes that are charged in this indictment, he states, "Everyone knew that the Muslims killed their own people in order to accuse the Serbs, so that the NATO could launch airstrikes against us because of crimes against civilians. I am convinced that Markale is a mini Srebrenica and a mini Žepa." He then has the temerity to tell this reporter how the crimes and the murders of thousands could be committed if someone had such an idea to do it. That is to say, if it had actually even happened. With respect to that, he says, and the question to him is, are you trying to say that the VRS did not commit mass crimes in Srebrenica? And his answer is, they didn't. The Hague allegedly has a list of mass grave locations. They say there are 800 bodies in one mass grave, 2,000 in another, and 3,000 in yet another one. They claim there are primary and secondary graves, alleging we moved bodies. What nonsense. It is not possible to carry out killings on such a mass scale in the presence of UN representatives, even if someone had such an insane idea. Your Honors, the evidence in this case establishes Mr. Bayara's involvement and clear responsibility for the crimes that are charged under the indictment. And we ask that you hold him responsible and you find him guilty. This concludes my submissions with respect to Mr. Bayara, and if I may, I would like to turn to Mr. Popović. The evidence of Mr. Popović's guilt and involvement in these horrendous crimes is clear and it is compelling. As I mentioned before, Your Honors, the Popović brief challenges the very foundations of the indictment, and because it, like the Bayara brief, is diametrically opposed to so many of the fundamental tenets of the prosecution's case, Many of the arguments raised in the Popović closing brief are dealt with in the prosecution's final brief. In particular, the Popović brief challenges the credibility of several inculpatory witnesses, as it should. Challenges among them PW128, PW101, who they assert knowingly gave false testimony. The brief similarly attacks the testimony of Momir Nikolic and Miroslav Derenic, as well as certain other significant inculpatory witnesses. The credibility of these witnesses are discussed in the prosecution's final brief, and I won't be addressing those. I will again try to confine my arguments to some of the more fundamental issues that respond to the defense brief, and also highlight Mr. Popović's involvement in and contributions to the JCEs as are pled in the indictment. Now, because the defense has devoted a substantial amount of time to the viability of the intercept evidence in this case, I think a few points should be made in that regard. Also, because the Bayar defense similarly challenges that evidence. Now, you heard the evidence of 28 intercept operators in this case from the ABIH 2nd Corps, Anti-Electronic Warfare Department, the 21st Division, and also the ABIH MOOP. You heard this over several months, including the testimony of platoon commanders, squad commanders, and other supervisors. You've received testimony on the process of interception, the mechanics of it, the notebooks, the printouts, the physical equipment, the training of the operators, and their technical backgrounds. You've also heard about the protocols and the standards that were in place and that they employed during the process of interception. You've heard from the prosecution witness or prosecution analyst concerning the intercept project that was compiled in order to validate and authenticate the intercept evidence. You've heard about the chain of custody, and you've had an opportunity to consider all of these issues in determining the admissibility of this evidence in advance of the defense case. I submit that all of these witnesses established beyond question the accuracy, authenticity, and reliability of this evidence. And the witnesses that have been adduced by the defense do not change this. You heard from Nado Blagojevic, who was a communications officer in the Drina Corps. He's the one who told you that interception was impossible. He also confirmed to you, though, that a failure to follow the rules would result in the type of intercept evidence that we have in this very case. That's a transcript 22333, 18 through 22. A report that was issued by Mr. Popović also confirms the occurrence of sloppy practices in the use of communication equipment within the VRS ranks. That's Exhibit 3D 00319. He states in that exhibit, we have obtained information that our units are extremely careless when using communications equipment. You've heard from defense witness Velo Pajic. He worked with the 67th Communication Regiment. He acknowledged that it was possible to intercept along radio relay routes. He's the one who, in giving an example about being able to change frequencies by moving up or down a megahertz or two, came up with a number, 783, as an example, which happened to correspond within a frequency, within a megahertz or two, to some 95 of 148 possible RRU 800 intercepts that are in the evidence of this case. And of course, you heard from Juro Rodic, who was the principal defense expert, who testified about the technical capabilities of the ABIH to intercept the VRS. I want to remind the trial chamber that Mr. Rodic conceded that the interception by the ABIH on both RRU-1 and RRU-800 radio relay devices was in principle possible. He stated at transcript 12513, lines 5 through 9, question, I think you indicated at the beginning of your testimony that generally it was possible for the ABIH to intercept communications. Answer, yes. This is what I stated with regard to the equipment that covered the frequency range of the RRU-1 and RRU-800. Under certain circumstances, it could intercept conversations. He then went on to talk about the circumstances or the reasons why they could not successfully intercept these communications. He reached his conclusions based upon calculations on the technical specifications of certain equipment that he reviewed. And he even suggested that one of the reasons they couldn't intercept VRS communications is because of an improper antenna orientation. In other words, he suggested they were pointing their antennas in the wrong direction. In light of the evidence in this case, it's clear that this suggestion is absurd. First, the radio relay networks in the former Yugoslavia were not a secret to any party to the conflict. They pre-existed that conflict, and they were known to everyone. Remember, there was a working map that was introduced into evidence in this case, P01468. It was an ABIH working map concerning radio relay communications. Mr. Rodic was confronted with this map and conceded that the map correctly depicted the radio relay devices on the route from Vlasenica through Zvornik, which has been contested by the defense in this case. The map clearly indicates that they had the ability and certainly had the knowledge as to where to intercept and where to direct their antennas. In addition, there's evidence that the ABIH knew the frequencies that the defense claimed never changed from 1993. That's evidenced in a document that's P02822, which reflects a working frequency which corresponded to the frequency plan that was issued in 1993. That was testified to by Mr. Blagojevic and testified to by Mr. Rodic. That frequency is 680 megahertz, and it corresponds to the route from Veliki Žep to Vlasenica on that plan. The conclusion from the defense arguments can only be that although the ABIH could clearly identify frequencies on a working plan from 1993, that for some reason in 1995 they weren't able to identify that same frequency, and they no longer knew where to point their antennas. In 1993, Drago Nikolic issued a report, and in his report, P03425, and it's dated 22 April 1993. In that report, he stated, "We have confirmation that the enemy is intensively intercepting our radio and radio relay communications, and particularly active are their interception centers in Tuzla and in Gorazde." You can see how obviously absurd the defense position is with respect to the capacity of the ABIH to intercept. And I'll leave it there, Your Honors. I'm confident that upon the review of all of the credible evidence in this case, you will find that this evidence is accurate, you will find that it's highly reliable, and you will find that it's extremely probative evidence of the circumstances in this case, and more importantly, of the acts and conduct of the accused. Now, In the case of Mr. Bayara, the intercept evidence in conjunction with other compelling documentary and testimonial evidence in this case establishes, just as it established in the case of Ruby Shirar, it establishes the same hands-on involvement in the crimes that are charged in the indictment for Mr. Popović. And it establishes his guilt beyond a reasonable doubt. This evidence can't be reviewed or viewed in fragments.
Mr. Van der Poel,
Yes, Mr.
I
President.
recall from reading, if I am not mistaken, because I don't have it here with me, Popovic's final brief, if I remember well. That could be Bayara, but I think it's Popović. There is a submission that there is evidence that up to, if I remember well, 8th of August of 1995, the antenna of the ABIH for the purposes of intercepting the antenna were directed towards another region where there was conflict too, in such a way that it therefore excluded in the possibility of intercepting communication inside the Drina core area of activity.
That's correct.
Yeah, but I don't know if it's Popović or not. But what do you have to say about this?
With respect to the orientation of the antenna?
And the conclusion then that would have eliminated the possibility of intercepting communications by and to the Drina core inside the other area to which the antenna were not pointing.
I can't answer the question, but I think I may have to go into private session to do it.
All right. Or if you prefer to leave it till later when we come to question stage, you can do that as well.
However you prefer, Mr. President.
It's up to you. I mean.
Okay, we can do it now.
Okay. Then let's go into private session.
Initially, I wanted to respond to the assertion made by the Popović defense in its brief, that there was no legal act putting the captured persons in the competence of the security organs, and that's at paragraph 675. I guess the suggestion here is that Mr. Popović had no responsibility for or involvement with the POWs in this case. Now, although this has been dealt with in the brief, I think it's important to point out that it is addressed in the testimony of Mr. Butler. It's addressed in his evidence, and in particular, the command responsibility report. It also bears pointing out at the outset that the involvement of the security administration, security organs, in matters relating to prisoners is contemplated in relation to their control of the military police. That's clearly set out in the rules, and Mr. Butler talked about that in transcript 19638, 1 through 199, and I should say 199, 40, 14 through 10. This has been illustrated in terms of the documents that have been produced in this case, that is the relationship between the security organ and the military police and prisoners in various documents. One of these documents is P00196. That is an example of how of the interaction between the security organs and the subordinate security organs, as well as concerns prisoners of war. In that document, it is signed by Mr. Popović, and it passes on a main staff direction concerning the treatment of prisoners. It reads that all prisoners, in part I should say, all prisoners, members of the army, members of the enemy army, are to be handcuffed or their hands tied with anything available immediately after their capture. They are to be searched, and all items are to be seized apart from their clothing and footwear. It goes on to say that an official record is to be compiled. It goes on and says that the location where POWs are collected must be such that the prisoners are fully secured, as well as the people from the security organ, from the intelligence organ, and from the military police organ that engages in the interrogation and guards POWs. The defense acknowledges they must, in paragraph 676 of their brief, that the commander of the unit is authorized to give any legal order to his subordinates in the security organs. They assert, however, that there is no evidence that either General Krstich or General Jovanovic or the superior commander issued any orders to Mr. Popović regarding prisoners. Your Honors, the proof of those orders, the evidence of those orders, is implicit in the conduct of Mr. Popović and his direct involvement with those prisoners and in the murders and detentions and forcible transfers that were committed in this case. Before I address some of the substantively charged crimes concerning Mr. Popović, I would like to address some of the claims made in the defense brief about Mr. Popović's involvement in the uncharged crimes committed in Bišina. The Popović brief challenges the evidence of his involvement in the execution of those 39 Muslim men there. He asserts what might be described as a partial alibi defense. Now, paragraph 654 of the brief. The defense argues that Popović was not there during the executions themselves, but only arrived there later during the burials of the 39 men that had been shot and executed there. They argue that he was elsewhere in Zvornik at the time the executions were committed and arrived at the time that the burials were underway. They introduced 3 statements pursuant to Rule 92 bis.
Please slow down for the sake of the interpreters. Thank you.
First, they introduced the statement of Milenko Kojic. That's Mr. Popović's brother-in-law, I believe. They introduced the statement of Dragiša Chojic, which is his co-worker, and then the statement of Slavis Vlačić. This is an individual who the defense asserts Mr. Popović was with that morning, 23rd July, 1995. I would submit that you should reject the alibi for the fundamental reason that neither Mr. Popović's brother-in-law, Milenko Kojic, nor any other witness can actually exclude that Mr. Popović was indeed at the execution site at the time that the killings were carried out, because no one has attested to the date of their purported encounter with him. Neither is there any precise date ascertainable from the proffered statements. Now, although the prosecution dispute the veracity or sufficiency of this partial alibi defense, even if you accept it, the fact of Mr. Popović's presence at all, that is to say, in any respect, at the scene of this uncontested mass execution is powerful evidence of pattern of conduct in this case. It shows that Mr. Popović knew about the executions. It shows that he was fully aware of the commission of these crimes, which he was obligated to put a stop to as a member of the officer corps of the VRS. and particularly as one vested with the power to arrest. Exhibit P00028 are the Military Prosecutor's Office guidelines for determining criteria for criminal prosecution. In paragraphs 2 and 3 on page 8 of that document, it reads, well, I should rather read both. If officers merely find out that units of the armed forces of the Army of Republika Srpska or their members have committed or are committing such acts and take no measures to prevent the consequences of the acts themselves and expose perpetrators to criminal prosecution, this in itself makes them answerable for those criminal offenses. It follows from the above that officers in all units must accept the obligation to draft reports on all incidents which might be regarded as criminal offenses, regardless of whether they have been committed by members of the Army of Republika Srpska or by members of the enemy side, and to report to the command any information learned about previous incidents. I think I will stop there, and you have it in evidence and can review it. What's important about this, though, is that these guidelines were issued, I believe, in 1992. This is something that Mr. Popović would necessarily have been aware of. And the fact that he didn't take the measures that are prescribed, indeed required, according to this document, is consistent with his participation in the criminal activities that he was observing. It tells you about his intent with respect not only to his involvement at this particular execution, but it also tells you about his intent as established by his presence at larger executions that took place earlier in Zvornik. The evidence concerning Bishina shows that elements of the Drina Corps military police, over which Mr. Popović has control ex officio, as well as the 10th Sabotage Detachment, were principally involved in carrying out the executions in Bishina. I will note that these same elements were involved in the crimes that were perpetrated at the Branjevo military farm on the 16th of July. You have the testimony of a member of that 10th Sabotage Detachment who testified also to the presence of Drina Corps military police that escorted his unit to the Branjevo farm the morning that those executions took place. Further, there is evidence that Mr. Popović had a relatively close relationship with the 10th Sabotage Detachment itself. There's testimony in the record which indicates that he used to come to the unit and would talk to the commander. That's at transcript 14013, lines 15 and 16. There is also other evidence concerning this relationship, which is set out in the brief, and I won't go into here. You had the opportunity to see and evaluate the testimony of PW-172 and PW-175, and both establish the direct involvement of Mr. Popović at Bishina. PW-172 places Mr. Popović at Bishina throughout the executions and the burial operation. You heard how he described his interaction with Mr. Popović and what he said to him after the executions were completed. He says, transcript 32573, lines 18 through 32574, line 9, I mustered the strength as much as I could, and I approached Vujadin Popović, and what I felt was either fear or pity. I don't know how to explain. I rolled the film in my head, the journey that I had taken and what had happened. I never had spoken to Vujadin Popović before or ever since that. I never approached him in any way. There was no need for me to do that. However, as I had been listening to the stories of other soldiers who were talking about officers, they all had nicknames. I didn't know how they actually addressed them when they spoke to them directly, probably calling them by their rank, and I suppose that I would have done that as well. In essence, General Jovanović was referred to as Gile in soldiers' conversations. Krstić was referred to as Curly. Mr. Vujadin Popović had the nickname Pop. At that moment, I mustered the strength to approach him. Something snapped in my head, and I didn't approach him as an officer at that moment. I approached him and I told him, "Pop, what has just happened?" And he never replied to me. This testimony leaves really no doubt as to either Mr. Popović's presence at or his hands-on involvement in coordinating, organizing, and directing the execution of the 39 men that were killed in that remote area. It is unclear why the defense brief at paragraph 658 states that PW 172, quote, saw Popović after the events and could only infer that he was there previously. On cross-examination and in response to counsel's question, defense counsel's questions, this is at transcript 32958, 11 through 17, it was put the following questions. Could you please answer whether you were certain about what you were telling us? Answer, I believe he was there. Question, if you say I believe or I think, does this mean that you're not absolutely certain? Just let me be more precise. While the executions were taking place. Answer, he was there. There's nothing equivocal about that. There's nothing ambiguous about that. As you know, PW 172's presence at the site is confirmed by vehicle logs which demonstrate his trip there. That's exhibit P04425. In addition, PW 175 transported the elements of the 10th Sabotage Detachment that formed the execution squad from Dragosevets that morning. His evidence is also supported by vehicle logs and reflects the fact that Mr. Popović was involved. You can find this at transcript reference 32782, lines 10 through 12. Popović's involvement in these crimes is further consistent with an intercept connecting him to one of the victims that was later identified in this case by DNA evidence emerging from that gravesite. Your Honors, the only thing that Mr. Popović was doing in Bishina on 23 July 1995 as the most senior officer present there was coordinating, organizing, and carrying out orders that he would have received from his commanders to execute these men. There's really no other explanation for his presence there. No other explanation. The evidence in this case shows that his knowledge, intent, and conduct were the same concerning the prisoners that were held in the schools in the Zvornik area. The Orahovac school, where he was present on 14 July. The Rochevich school, where he was present on 15 July. The Kula school, where he was present on 16 July. The nature and extent of Mr. Popović's involvement in the Bishina executions virtually parallels the circumstances of his presence and participation in the crimes that were committed in Zvornik. And before I address some of the more compelling evidence of Mr. Popović's involvement in those executions and his significant contributions to the murder JCE, I will address his involvement in the forcible transfer JCE. Mr. Popović's involvement in the JCE to forcibly remove the populations of Srebrenica and Žepa is clear in the record of this case. Mr. Popović was involved in a discussion with General Krstić just after the Hotel Fontana meeting, in which the buses that were used to transfer the women and children from Potočari was discussed. General Krstić, as you know, was heavily involved in the mobilization of the transportation and buses from the early morning of 12 July, well in advance of the Hotel Fontana meeting. The evidence shows that Mr. Popović was engaged in a discussion with General Krstić, which involved security issues for the buses, including the structure of the column. That you can find in transcript reference 14590, lines 2 through 5. Mr. Popović's assignment of Momir Nikolić to assist in and to coordinate and organize the separation of Muslim men in Potočari and the transfer of the women and children also demonstrates his immediate involvement in that process. At paragraph 386 of the defense brief, they assert, quote, there were no reasons why Popović should have thought the evacuation was being carried out illegally. First, Your Honors, you have clear evidence in this case as to the nature of the forcible separations that were carried out, the brutality of those acts, and the acts that were perpetrated against the separated men. I won't repeat that evidence because that, as you can imagine and as you know, has been extensively addressed in the prosecution's final brief. We know that Mr. Popović was physically present in Potočari on the 12th and the 13th of July, and he had an opportunity to observe and to become aware of the rampant and serious abuses and crimes that were being and had been committed by VRS forces that were there. On 13 July in particular, he was seen near the White House, where we know that men were separated. Separated men were detained, they were physically abused, and even some were killed. You recall the testimony of Dutch Bad Officer Major Rutten, who saw Mr. Popović there. He saw him speaking to serve officers, and he saw them giving them directions, instructions. Now, Mr. Rutten was an experienced officer himself and observed that Mr. Popović appeared to be in command and authority. In other words, he was a clear presence there. There is ample evidence of criminality and illegality in plain view in Potočari. Mr. Popović had to have been informed about that, if not, had seen it personally.
Mr. Van de Puer, I don't have that final brief in front of me, but I take it what Mr. Popović referred to in his final brief is forcible transfer of women and children. But you are now addressing the separated men.
I am. The reason why is because the forcible transfer of the women and children was facilitated by the separation of the men, and also Mr. Popović was involved in the security aspect of the transportation of the women and children, as I've indicated, as referenced in the transcript.
Could you expand the meaning of facilitated? So with the men, you are suggesting that it would be more difficult, impossible to transfer the women and children?
No, sir. No, Your Honor. I'm not suggesting that it would be impossible. What I'm suggesting is that it creates a situation of insecurity among the people that are being transferred. When you're separated from your loved one and you don't know what's going to happen to them, it makes it easier, or makes a person more complicit or docile in terms of moving them. It is easier to hold a person, for example, in detention when they don't know what's going to happen to their loved one, and it is easier also to keep a loved one away from a person when they don't know what's going to happen to them when they're held in detention. The consequences of your actions when you don't know what the results are going to be is what influenced and substantially contributed to the climate of fear that facilitated the forcible transfer of the women and the children in Popović. And the separation of the men was an integral part of that fear. It was an integral part of the impetus.
Thank you. Proceed, please.
Thank you, Judge Clark. In terms of the illegality of the forcible transfer, this is also underscored in an intercept P01113. It's a 12 July intercept at 12:50 hours, and it involves General Mladic. And it underscores what Mr. Popović must have known. I will point out, frankly, it's not addressed to Mr. Popović. But it is an intercept in which General Mladic says, when he's told that the buses are rolling in order to pick up people and transport them out, he says they've all capitulated, they've surrendered, and will evacuate them all, those who want to and those who don't want to. He then goes on to talk about the security issues concerning the movement and transportation of those buses. These are the very same security issues that a witness in this case overheard being discussed by General Krstić with Mr. Popović. To the same extent that Mr. Popović knew of the security issues relative to the transfer of the population on those buses, the structure, the clearing of the roads, the mines, etc. He must have known of the illegal plan. He must have known of the plan to send those who wanted to and those who didn't want to out. At 9:30 in the morning on 13 July, Mr. Popović met with General Mladic and General Krstić, as well as Dragomir Vasic at the command of the Bratnac headquarters. The topic of discussion there was indeed the continued evacuation of the remaining civilian population from Srebrenica to Kladin. That meeting is memorialized in a dispatch that was prepared by Dragomir Vasic, and it's P00886. Mr. Popovic's presence at that meeting is memorialized, I should say, documented, I should say, in Momir Nikolić's statement of facts at paragraph 8. I don't believe that the Popović brief addresses the forcible transfer of the thousands of separated men from the column who were taken to Zvornik where they were executed. But his involvement in the transfer of these men is amply established in the record of this case. On 13 July, Mr. Popović calls Drago Nikolić to tell him that the prisoners detained in Bratunac were to be transferred to Zvornik, where they were to be killed. The following day, Mr. Popović, Mr. Bayara, and Mr. Nikolić meet at the Zvornik Brigade headquarters, where, based on the events that both preceded and followed that meeting, indicates that they clearly coordinated and organized the transfer and detention of those prisoners. Following the meeting, Mr. Popović led a column of thousands of prisoners from Bratunac to Zvornik, where they were received by Mr. Nikolić, and they were distributed in the schools in the Zvornik area, which had been and were being prepared to carry out their execution. You've heard the testimony of PW-138. The defense argue at their brief at paragraph 489 that that witness just wanted to protect himself from the responsibility of leading the convoy by stating that he was traveling behind Popović, who was in his Golf and leading the convoy. Now, it's unclear exactly how that strategy or that admission would accomplish this end, since in either event, PW138 would have been admitting that he was participating. Now, he could have simply denied his involvement altogether. But in fact, it's his admission of his involvement that lends to the credibility of his evidence. And it's the detail of his testimony that bears the hallmarks of the truth. His testimony shows Mr. Popović's hands-on style of involvement with the transfer of these prisoners, and it is compelling. If you recall, PW138 testified how Mr. Popović told him to meet him near a bus station in Bratunac on the morning of 14 July. He told PW138 where to park an APC that he had asked him to use. He appeared in his blue Golf and directed PW138 to move up. He came back and he told him to move up some more. He then told him to refuel the APC if he needed to refuel it. He then came back, and after a column of buses that had assembled behind the APC, Momir Nikolić testified that he estimated it was about 1.5 kilometers long. PW138 testified that he followed Mr. Popović up to Orahovac, and Mr. Popović set the pace as he followed. The evidence, I should say this evidence rather, also ties Mr. Popović obviously directly to the murder operation itself. And it underscores his essential and significant contribution to its implementation. It shows his coordination and organization in the implementation of the orders of the VRS command structures, and together with Drago Nikolić and Ljubiša Bejara and the Zvornik Brigade Command, its personnel and resources, it shows how this operation was coordinated. The clearest indication of Mr. Popović's knowledge and his involvement in the murder operation is demonstrated, as I say, by his blunt statement to Momir Nikolić on 12 July that all the Balia have to be killed. Momir Nikolić suggested potential detention sites and execution sites with Mr. Popović, which he says were discussed. You then have the call to Drago Nikolić on the evening of the 13th. Paragraph 244 of Mr. Popović's brief disputes the evidence that he called Drago Nikolić to inform him of the plan to transport the Muslim men held in Bratunac in the Zvornik area, to the Zvornik area, in order to be killed. And the reason they give, quote, he would never have conveyed it through a telephone conversation because he had warned of discipline during radio communications in his capacity as a security officer. Now, Your Honors, judging from the sheer volume of the intercepted material in this case, including several significant ones concerning Mr. Popović directly, this argument is completely vacuous. As imprudent as it may be, the evidence in this case shows Mr. Popović on several intercepts. It even shows him on intercepts with Drago Nikolić. And while this call in particular would have been obviously a very sensitive one, it clearly does not preclude the fact that it occurred, that it would have been made. The defense dispute the existence of any plan to kill the detained Muslim and boys before 14 July.
One moment. Yes.
Ja się zaista izvinjavam.
I really apologize, but I do have to go out for a moment.
Security, please escort him. Shall we proceed, Colonel Beara, or I don't think Mr. Soich is not dealing with him at the moment.
I think we can proceed, Mr. President.
Okay, thank you. Yes, go ahead.
Thank you, Mr. President. Sure. In their brief, paragraph 457, the Popović defense argues that if such a plan had existed, it would have been implemented immediately on 12/13 July. Now, clearly, there are several reasons why this would not be the case as well. First, it took time to separate the large number of men in Popović. It took time to round up the thousands of prisoners that continued to be captured through the 13th of July. There's little doubt that the VRS was not prepared for the large number of prisoners that they managed to capture over that period of time. And also the large number of prisoners that they had custody of by 13 July made it impossible to carry out their murders quietly and efficiently in Bratunac. International agencies were still operating in the area. Now, in the interview that I referred to before involving Mr. Bear, he states, it was not possible to carry out the killings on such a mass scale in the presence of UN representatives. And that makes sense. There's truth to that, given his involvement in these crimes. The evidence shows that Mr. Popović was present at Orahovac. He was at Rocevic, and he was at Kua. The Popović brief at paragraph 682 denies the prison states that they deny the prisoners in Orahovac were under the control of Mr. Popović. It's not clear whether this is a reference to a command function, control in the command sense, or it is in its colloquial meaning. In either event, the evidence establishes clearly that he was there. Aside from PW-138, whose testimony the Popović defense impugns directly, there is evidence from Tanachko Tanic, which puts him there. In addition, there's evidence from Milorad Brčaković that puts him there. And in addition to that, there's the evidence of PW-101, who described an officer that was at the execution site that matched Mr. Popović's description. In respect of the evidence presented, in respect of this evidence, that is the evidence of PW-101, who said he saw someone matching Mr. Popović's description essentially that evening, at their brief, at paragraph 513, the Popović defense asserts that he was not in Zvornik on the evening of 14 July. And in respect of that, the Popović defense called Gordan Bielanović. And I'm sure that the trial chamber recalls his testimony because it was completely unreliable and it was completely contrived. Mr. Bielanović testified, first of all, as an alibi witness and stated that when it comes to dates, when it comes to exact dates and times, it's difficult. You may recall that he testified that he did not leave Vlasenica until after the fall of Srebrenica. This was completely contradicted by a prior statement that he had given 9 March 2001 to Mr. Petrušić in connection with his defense of General Krstić. In that statement, he claimed that he was present in Srebrenica from 5 through 12 July. And when he was confronted with this contradiction, his explanation was barely intelligible. At paragraph 618 of the Popović brief, The defense assert that the testimony of Zvornik Brigade 2nd Battalion Commander Shreko Achimovic is not credible. As the prosecution has indicated, there were several witnesses in this case who, because of the nature and extent of their involvement in these events, tended to minimize their personal exposure. Shreko Achimovic was one of those witnesses. That, of course, does not mean that everything that he says was not true. Mr. Popovich's presence at the school cannot be explained away by some motive that could be attributed to Mr. Achimovic to set him up, to frame him. There's no evidence of that. Further, the fact of Mr. Popovich's presence at the Rochevich school is characteristics of his presence in Orahovac. It is also characteristic of his presence at the Kula school, and it is also characteristic of his presence at Bishina, all of which support Mr. Achimovic's testimony concerning his presence at Rochevich. He testified that he spoke to Mr. Popovich between 8:30 and 9:30 on 14 July, the day before Mr. Popovich came to the school. He spoke to him at the brigade command headquarters. Now, given the contrived alibi defense of Goran, I think it's Jordan Bilanovich, it is entirely plausible that Mr. Popovich would have been at the school. There were executions that were being carried out in Pekovsky on the 14th of July. There were executions being carried out in Orahovac on that day. Mr. Nikolic was in that area. Mr. Bayara was in that area. It makes sense that Mr. Popovich was in that area. And it makes sense that he would have been at Rochevich on the 15th, having been at Orahovac on the 14th, and having been at Kula on the 16th. He was an integral part of this murder operation, and together with Mr. Nikolic and Mr. Bayara, that's exactly what he was doing. He was implementing the murder operation. Now, with respect to his presence at Pilica, that's paragraph 683 of the defense brief. The defense denies that Popovich was at the Kula school at around noon on the 16th of July. The defense concede, however, and I quote this, that it is possible that there was a person fitting his description there because there were many men fitting the description of Popovich, and also many men with mustaches have been seen on many videos and photos during this trial. Now, I've already gone over some of the reasons why Slavko Perich's identification of Mr. Bayara and Mr. Popovich is reliable. But you will recall also that with respect to Mr. Popovich, Mr. Perich testified that he observed someone refer to him as Pop. And we know from the intercept evidence in this case and the testimonial evidence in this case that this was Mr. Popovich's nickname. PW-172 testified to that also. Now, while the defense have argued that a subordinate would not refer to Mr. Popovich as Pop, PW-172's testimony actually speaks to the contrary. In addition to that, there are several instances in which you can see that officers that are junior to Mr. Popovich refer to him as Pop in the intercept evidence, among them Drago Nikolic. The defense's concession that it is possible that somebody fitting the description of Mr. Popovich was in and around Pilica on the 16th July at noon or somebody with a mustache may have been there. Of course, neglects the aspect of Mr. Perich's identification of Mr. Popović as Pop. That somebody referred to him as Pop. So the question then is, while there may have been other men fitting Mr. Popović's description, running around with mustaches in the VRS, how many of them also went by the nickname Pop? How many of them were actually called Popović? How many of those would have been hanging around with somebody who just happened to look just like Rubisha Beara? How many of those would have happened to have been referenced in intercepts corresponding to the events in Pilica on the same day when they happened to have been seen there? And how many of those would have had their names appear on fuel receipts that were directed to Pilica? The evidence that Vujedin Popović was present at the Kula school and involved in the executions there is supported by independent documentary evidence, and it is established in the case beyond a reasonable doubt. The corroboration of that involvement is found in the intercept evidences I've mentioned, which I'll briefly outline. You recall the intercept from 16 July at 13:58 hours. This is an intercept, which is a four-part intercept, which involves a duty officer of the Zvornik Brigade, Milorad Turbic, who is attempting to get fuel that has been requested by Mr. Popović. And that's the intercept that talks about the 500 liters of D2 fuel. And he tells the duty officer that Mr. Popović needs it. He then gets on the phone and talks to Mr. Bashevich, the technical services officer of the Drina Corps Rear Services, and he tells him that he conveys the message, 500 liters of D2 are urgently being asked for by Mr. Popović, or else the work he's doing will stop. He speaks to Pavle Golic, and he says, Pop just called me, told me to contact you. 500 liters of D2 have to be sent to him immediately, otherwise his work will stop. And he says, yes, 500 liters, or else his work will stop. He speaks to another unidentified participant and says a bus loaded with oil is to go to Pilica village. There's clear evidence in this case, Your Honors, that connect Mr. Popović to those executions. You recall that there are additional intercepts where Mr. Popović is referred to as being in the Zvornik area. There's the duty officer's notebook, which indicates also at 1400 hours that a request for a bus with a full tank and 500 liters of D2, and that the duty officer and Golic have been informed of that. It's a prime example of how the security organ, the security administration, is functioning within the normal command structures of both the brigade and the Corps. You've seen the fuel dispatch order that's dated 16 July, which reads for Lieutenant Colonel Popović. And you've heard testimony that there was in fact fuel that was delivered near Pilica. You've seen the intercept at 21:16 hours on 16 July, P01201, where Mr. Popović reports to the Drina Corps Command. He speaks to Ljubo Rakic, actually. Tell the general I finished the job, I finished the job, I finished everything. And then on 17 July at 16:22, there's another intercept where Mr. Popović speaks to his commander, General Krstić, and he says, hello, it's Popović. Boss, everything's okay. That job is done. Further on in the intercept, he says, that all gets an A. A, the grade is A. Everything is okay. That's it. Bye and take care. Now, at paragraph 590, the defense brief cites Krstić the Kirstich appeals judgment for the proposition that no reasonable trier of fact could have concluded that this was the only reasonable inference that could be drawn from the evidence. That is, that the job that he was doing concerned the burials and executions on the 16th and 17th of July. We cite the Kirstich appeals judgment, and that's at paragraph 115 of that judgment. I would submit that the record before this trial chamber is a different one. It's different than the record that was before the Kirstich trial chamber. You have here, in this record, eyewitness testimony placing Mr. Popović and Mr. Bayar at the Kula school. And that frames the context of this intercept. On the record before you, the only reasonable inference that you can draw from this intercept in view of Mr. Popović's presence at the school is that this is exactly what he's doing, is he's reporting on the only job that he's doing in the area. And he's reporting on the successful completion of that operation. Your Honors, there's only one reason that explains Mr. Popović's presence at any one of the execution sites in this case, let alone the several. He was there to see that the murder of the Muslim men and boys of Srebrenica was carried out efficiently, and he was there to see that it was carried out quietly. He was there to see it to its completion and to see to its concealment. And he was there pursuant to the orders of his commanders to galvanize the resources needed to carry out this operation through the command structures of the VRS and especially of the Zvornik Brigade. His guilt as a member of the forcible transfer JCE, as charged under the indictment, is proven to no lesser extent. And based on the record of these proceedings, Your Honors, Mr. Popović should be found guilty of each count under the indictment. There is no persuasive evidence in this record of any remorse from Mr. Popović, nor of any legitimate mitigation for his conduct. And I would ask you, we ask, that you take this into serious consideration in your judgment on the issue. I thank you for your indulgence, and more importantly, I thank you for your patience and attention. And this concludes my submissions.
Thank you, Mr. Van der Poel. I take it you are next, Mr. Mitchell. We're only 5 minutes away from the break. I suggest that we take the break and you start immediately after, if that is convenient, agreeable to you. Okay. Thank you. So we'll have a 25-minute break now.
All rise for your evaluation.